Welcome to Faith and Freedom. For the next few minutes, we hope to inform, inspire, and encourage you as we discuss the legal victories and challenges to your fundamental freedoms and religious liberties. Faith and Freedom comes to you from Liberty Counsel, a civil liberties education and legal defense organization. Join us now as Matt Staver, the President and General Counsel of Liberty Counsel, explains the latest legal issues all across this country in the courtrooms of America. Liberty Counsel is winning the battle for your constitutional freedoms.
Wisconsin Supreme Court upholds traditional marriage. I'm Matt Barber, Director of Cultural Affairs with Liberty Counsel and Associate Dean with Liberty University School of Law, in for Matt Staver today. And joining me in studio is Sean Akers, a Dean of Liberty University's Helms School of Government and Policy Analyst with Liberty Counsel. Well, Sean, Wisconsin, which is considered for the Midwest a pretty liberal state, has disappointed homosexual rights activists by unanimously deciding with a 7-0 ruling that the state's constitutional amendment defending the definition of natural marriage as between one man and one woman, that it does not violate anyone's constitutional rights, that this is a perfectly constitutional ban on radically redefining the very important institution of marriage in that state. And this just, I think, among other things, goes to highlight the fact that different states across the country, the majority of states, even liberal states like Wisconsin, understand that marriage as between one man and one woman is a fundamental cornerstone of any healthy society, and that this notion that somehow it's a constitutional violation to keep one man from so-called marrying another man, something that defies the very definition of marriage, that is in no way violates anyone's constitutional rights. And this again underscores the fact that we are going to continue to see these states that have these disagreements coming to different decisions on this issue. And it, I think, again underscores the importance of DOMA, the Defense of Marriage Act, the Federal Defense of Marriage Act, which guarantees states the right to maintain the definition of natural marriage in those states.
Well, Matt, if there's one important thing about this, it's important to keep in mind that Wisconsin's not a conservative bastion. Now, these judges, in doing this, they didn't necessarily say they like or dislike or agree with or promote the state's ban, but what they did do is fail to find any constitutional reason that the people of Wisconsin couldn't vote on this measure and say that they choose, as the sovereigns of Wisconsin, to say that marriage is going to be between one man and one woman. That is a very encouraging trend. Now, it's also very likely, Matt, that where one state finds that there's no constitutional reason to ban it, if another disagrees, then I think it's fairly certain that eventually we're going to see this issue as a split between the states and the United States Supreme Court. So when we talk about electing presidents, when we talk about electing those who put judges in their seats, this is what it all comes down to, is at some point in the future, some justice of the Supreme Court, placed there by some president that you and I elected, is eventually going to make the call on this major issue between states that disagree. But for right now, we should be very upbeat about Wisconsin's decision that there's nothing in the U.S. Constitution that can stop the people of a state from deciding that marriage is between one man and one woman.
And in addition to that, certainly that there's nothing in Wisconsin's Constitution that would additionally require that Patrick Henry can marry Henry Patrick, as I often say, and it goes to just how ridiculous it is that we're even having this conversation, Sean. That the framers of the United States Constitution could not have even conceptualized the ridiculous and oxymoronic notion of so-called same-sex marriage, much less considered it a fundamental constitutional right. Homosexual behavior was considered the sin that dare not speak its name. They wouldn't even discuss it. It was considered so repulsive and detestable. And to somehow say that sodomy is deserving of constitutional protections, and that our founding fathers would have believed this, just does not track with history. It doesn't track with Scripture. Certainly, the Bible being the number one most quoted book by all of our founding fathers, and the Bible is unequivocal that sexual behavior between people of the same sexes is as Scripture calls it, an abomination. It's sin. It's sexual immorality. Alongside other forms of sexual immorality, it is sexual immorality. And so we see Wisconsin looking specifically at the legal issues. And to give a little more background here, there was a referendum in 2006 where voters were asked to vote on to limit to one man and one woman any, quote, legal status identical or substantially similar to marriage. Again, that's just maintaining, because the traditional definition of marriage, the institution of marriage, is under attack and has been under attack. The people, through ballot initiative, are placed on the defensive, where, oddly enough, they have to actually redefine formally what is marriage, what marriage has always been in the United States. They have to say, okay, this is what it is. Now quit trying to attack it and radically redefine it. Well, the court said the legal challenge basically said that there were more than one issue associated with this, and that any amendment, any ballot initiative can only look at one issue. Well, the Wisconsin Supreme Court said no. A, this is constitutional. B, this is discussing the same issue, civil unions, same-sex marriage. It's all kind of one and the same. It's all the same thing, just with a different name, something that we've been saying all along. Domestic partnerships, same-sex unions, civil unions, they're all fall under this umbrella of same-sex marriage. It's all the same thing with all the rights and responsibilities. By adding one word and calling it marriage doesn't substantially change it. Well, the U.S., or rather the Wisconsin Supreme Court, got it right.